Thank you, ladies and gentlemen, for joining us for another edition of the Free Exchange of Ideas with Donovan and John. We are here to help you out. Now, let's just get to it.
Yes.
Okay. Hey, thank you for coming back for another edition of the Free Exchange of Ideas with Donovan and John. Today we're going to talk about the 14th Amendment, and because the 14th Amendment literally covers the first 5 amendments, it's referenced. They're all referenced back and forth in court cases. We're going to do the first 2 sections of the 14th Amendment, and then we'll cut and we'll do the other. We'll do the next 2.
The last 3.
Next week.
Yeah.
Last 3, you want to try it, you think?
Yeah, I mean, the last one is pretty, it's, Congress shall have no power to enforce by a privilege of this article. Like, it's like one sentence.
Yeah, but it's probably the most important one. Anyway, so
I don't know, I like number 2.
I like number 2 as well. All right, so let's go ahead and get started. Donovan, you want to read it?
Yeah, we can do that.
Okay.
All right, so thank you for sending it to me, because I, for whatever reason, can't find them. So 14th Amendment.
Bookmarks.
I hadn't gotten that far yet. I usually have like 10 or 15 bookmarks, but I hadn't done any of that. So, and all the ones I did have, I lost when I rebooted my computer 2 weeks ago when we first started talking about this. And why I said we should do the 14th Amendment.
Donovan's fault. All this happened.
Why would I say that? So yes, so this is the topic I wanted to do, and studied it pretty good, but last time I did any kind of research on this was over a week ago. So here we go. Full text of the amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's section 1. Section 2, which me and John also talked about offline a couple weeks back. Representatives shall be apportioned amongst the several states according to the respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime. The basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. So,
end of 2.
Yep. 2. Yep, that's 2. 3. Yeah, so that's it. Those are the first 2 sections. So we want to go first, Johnny?
Sure. I got to go back to my bookmarks where I know things are.
Bookmarks?
I like Cornell Law. I just like their site. I think it's pretty good. So an overview, which is one of the things I really like about Cornell Law site, is they do an overview. The 14th Amendment contains a number of important concepts, most famously state action, privileges and immunities, citizenship, due process, and equal protection, all of which are contained in section 1, which is why we're going to make this just 1 and 2. However, the 14th Amendment contains 4 other sections. Section 2 deals with apportionment of representatives to Congress. Now, I've got a couple of cases here about specific.
Dred Scott.
No, Dred Scott is not one of them.
Oh.
I mean, in this particular case, I don't think. Hold on, is that the first one? No. I have Scott v. Sanford, which is for African Americans. 1857, the Supreme Court held that African Americans were not U.S. citizens, even if they were free. The 14th Amendment, however.
That was Dred Scott.
Okay, the 14th Amendment, however, guaranteed that everyone born or naturalized in the United States and under its jurisdiction would be a United States citizen. It also ensured that federal citizenship was also made primary, which meant that states could not prevent freed slave from obtaining state citizenship and thus federal citizenship. As such, the 14th Amendment effectively overturned Sanford versus Scott.
So that was it overturned. It fixed what the Supreme Court screwed up on.
Right. So, Native Americans in Elk versus Wilkins, 1884, the Supreme Court held that children born to members of Native American tribes governed by local tribal governments were not automatically granted citizenship under the 14th Amendment. Congress, however, granted citizenship to Native Americans in 1924 when it passed the Indian Citizenship Act. Chinese Americans in United States versus Wong Kim Ark, 1898. The Supreme Court held that when a child is born in America to non-citizen Chinese parents, very specific, that child is a United States citizen. The court in Wong Kim also applied that ruling, quote, all persons born or naturalized in the United States, end quote, finding that those persons, quote, are citizens of the United States and of the state wherein they reside. There's, again, I've got cases and cases and cases and cases I can go through. And what I am going to do is put the link to this section. It'll be the first link up there in the description box below. And while you're looking at that, go ahead and do me a favor and push that like button and share this if you'd like already. I'd really appreciate that. Which one were you going to do? Were you going to do Dred Scott first? And I stepped
No, that was like the very first kind of it was 14th Amendment was created to correct from what I studied.
Yes.
And read and listened to that the 14th Amendment was created to help correct the decision of Dred Scott. And what citizens are, 3/5 compromise and all that other BS.
Right.
That was going on. So that's what the 14th Amendment did. And I guess it was kind of it was being used to kind of force the southern states back into the Union. It was kind of one of the ways it was described.
But I just want you to go ahead and do your thing right now, if you can.
Okay.
Whatever one you want to do.
So we talked about the first two sections, right? That's.
Well, I suppose.
Which I read, right? That's kind of what. Yeah. So, excuse me, that was a hard sneeze.
Oh, bless you.
Yeah. So it talks about representatives and how that's going to be taken care of and how that's apportioned, which is important. I think it's even more so today. More people are voting. This was just applied to white males.
I don't want to discuss
it even says that in there, but
actually doesn't say white males. It says males.
Number of male citizens. I thought it said that in around Reddit.
Does not.
But that's what they mean.
It does not. Specifically stating males.
Excuse me.
Because that's what males are the ones that were counted. And stating that any male citizen is bringing blacks and other races into that fold. So the southern states couldn't run their, in essence, their Jim Crow laws, which they did create
which they did later. So and then got held and then got supported by the Supreme Court as well. So
right. So
my fault. You're right. Excuse me.
All right. It happened often. You just don't realize it.
Hard sneeze. Yeah, so that was the first two sections that we're talking about tonight. So and I also think it's
there's the state action clause of the 14th Amendment, and that's in the first clause.
What?
That declares the state cannot make or enforce any law that abridges the privileges or immunities of any citizen. In civil rights cases in 1883, the Supreme Court ruled that the Civil Rights Act of 1875, which prohibited racial discrimination in public accommodations, was unconstitutional because it tried to regulate private actors. The court decided in U.S. v. Guest, 1966, that the enforcement clause gave Congress the power to regulate the private of individuals who conspired with state officials to deprive people of their rights under Section 1 of the 14th Amendment.
What case was that?
That is United States v. Guest, 1966.
Oh, okay. Ooh, that's one of the newer ones. Yeah.
Yeah. And then there's United States v. Morrison, 2000. Supreme Court rejected Guest and struck down part of the Violence Against Women Act that provided a civil remedy for victims of sex-related violence. My fault. I don't recognize that case, and so I can't really speak on it. I apologize. The court also handled a number of cases dealing with racial discrimination by private actors. Shelley v. Kramer, 1948. Decided that judicial enforcement of a private restrictive covenant that prohibited non-Caucasian occupants violated equal protection to a black buyer, even though enforcing private restrictive covenants was generally valid and enforceable. In Burton v. Wilmington Parking Authority, a restaurant which leased space in a public parking garage was found to engage in racially discriminatory practices. Supreme Court, influenced by the fact that the garage was used for public parking, ruled that the restaurant was closely tied to the state in such a way that the discrimination could be considered state action. As such, the Supreme Court decided that the restaurant's discrimination unconstitutionally violated the Equal Protection Clause. Like I said, there's a ton of cases before we get to Privileges and Immunity Clause.
Yeah. Yeah, it was just, I was like, I remember reading I'm looking at it right now, the slaughterhouse cases.
Slaughterhouse cases, yeah.
In New Orleans, Louisiana.
That was
monopolized, consolidated, trying to control basically pollution is what it looks like was what's going on. Yeah.
And keep the little guys out from under them.
Yeah. So, homie, don't you know me, right? Right. So it was interesting to see how it's, and that's the interesting thing about and we talked about it even, off the air, but how the 14th Amendment is applied so broadly to so many cases and onto the other amendments and on, to women, the right to privacy and stuff like that with contraception and stuff back in the 60s and things such as that. So it's interesting to see how it has been broadened because it's really more of a 20th century, what's the word I want to use? Trend, is that it was broadened to encompass a lot more.
Well, I think,
which I think is a good thing, but so
I was going to say, I think when it was written, it was meant to be very broad, but Supreme Courts at that current time wanted to view it much more narrowly in order to kind of keep the South happy and everybody else kind of happy, and it didn't work.
Yeah.
Which is not uncommon for that practice in general. You can't please everybody. You could piss everybody off.
Yeah. But as I'm looking here at Plessy versus Ferguson, which you're talking about, 1896, and it was a 7-1 decision. And it's interesting because I didn't know this. So Justice John Marshall Harlan authored the lone dissent. Passionately, he clarified that the Constitution was colorblind, railing the majority for an opinion which he believed would match Dred Scott in infamy. So, Justice
Harlan. Right, and at that time, as you mentioned, 7-1, eight judges. I can count. Only 8 judges. Yeah, exactly. And now we currently have 9, and there's an argument being made for 14. There's nothing in the Constitution about how many judges are seated at the Supreme Court. So there have been 5, there have been 8, 9, there have been, I think there was 11 at one time.
Yeah, it's been 11, yeah. So I'm all for increasing the size of it myself, obviously.
Right, and almost always it's been odd numbers.
Yeah, so it's interesting that this is 8, you're right. So 7-1, but there's odd number would make sense, you think, so.
Right, exactly, and that's the point. The point is that there's, for this current court layout, 4 on either side, and then the Chief Justice in the middle to make that, to weigh in only if needed. Now, as far as I know, all the way back to Rehnquist, the Chief Justice has always weighed in. I'll tell you what. Let me just move on here a little bit.
Yeah, we can
Into
do that. I'm looking
privileges and
forward to it
immunities.
because I can't find them now.
Okay, so to continue,
All right.
we just touched on a couple of the other cases there, but in privileges and immunities clause, which is also still part of that first clause, there are some debate over, or there has been some debate over the meaning of the privileges and immunities clause, with several possible original meanings. A question arises as to whether the clause meant that all state laws should be applied equally to its citizens, or that state laws should have certain substantive content. The substantive view can be further divided into two categories. One view is that these privileges and immunities include all of the rights in the Constitution, including the Bill of Rights. Thus, this view sees the purpose of the Privileges and Immunities Clause as applying all of the rights in the Constitution to all of the states. Another view is that it only meant to make the Bill of Rights applicable to the states. In Cornfield versus Coriel, 1823, an early case concerning the Privileges and Immunities Clause, found that the clause protects certain fundamental rights of all citizens. However, in slaughterhouse cases, that's 1873, the Supreme Court rejected that interpretation, holding that the privileges of national citizenship were substantive, but they came about as a result of the federal government, the Constitution, or other laws. The fundamental natural rights were not included, and thus equality function of the Privileges and Immunities Clause was taken over by the Equal Protection Clause, and substantive functions were taken by the Due Process Clause. So they were basically split. Aside from one case that was later overruled, pardon me, the Supreme Court did not use the Privileges and Immunities Clause as the basis for the decisions until 1999 with Sands v. Roe. That's 1999, where California set welfare benefits for new residents at a certain level equal to what their former state provided for the first year of residency in California. The court decided that part of the fundamental right to interstate travel was for new citizens of a state to be treated like any other citizen of that state. And then we move down to a due process clause. And this one's a big one because the Fifth Amendment and the 14th Amendment both contain a due process clause. Although the 14th Amendment applies explicitly to the states, the Supreme Court has interpreted the due process clauses in both articles as having the same meaning. Justice Frankfurter describes in his concurrence in Malinsky v. New York, 1945, to suppose that due process of law meant one thing in the Fifth Amendment and another in the 14th is too frivolous to require elaborate rejection. In other words, he said they're the same, and to say they're different is BS in essence. Due process is generally understood to contain two concepts: procedural due process and substantive due process. Procedural due process guarantees fairness to all individuals. This fairness might require different elements to be accused, including the opportunity to be heard, given notice, and be given a judicial decision with a stated rationale. As a basic rule, the more important the right, the stricter the procedural process must be. The Supreme Court has defined what property and liberty interests are in different cases. In the case of Board of Regents v. Roth, 1972, the court held the 14th Amendment does not require opportunity for a hearing prior to the non-renewal of a non-tenured state teacher's contract unless he can show that the non-renewal deprived him of an interest in liberty or that he had a property interest in continued employment despite the lack of tenure or a formal contract. That one's a little deep and thick, and so I'm going to tell you right now, I don't really understand all of that. But again, that is just a review of the overall case. So I'm sure there's a lot of nuance in that if you look at the case, you'll be able to see that. I'm not going to do it. I certainly don't expect you to go that far, but I think it's important to understand, to know that these cases exist. And honestly, if I was you, I would bookmark this and hang on to it because, like I said before, the 14th and the first 5 amendments, 1 through 5, uh, are so tightly tied together that they can't hardly be separated in court. And it's important that you understand that. Um, Substantive due process, although procedural due process is widely accepted, substantive due process is a bit more controversial. Modern debate regarding the substantive due process clause tends to focus on certain liberties which the Supreme Court has interpreted as belonging to citizens, with a large focus on economic liberties such as the right to create private contracts. You still looking there? You look really
I
serious.
am, and it's bugging me.
All right, I'll just kind of continue down then. Economic rights. Starting in the late 1800s, the Supreme Court used substantive due process to uphold a number of economic rights. In Lochner v. New York, 1905, the Supreme Court held that the 14th Amendment protects a general right to make private contracts and that a state may not interfere with this liberty in the name of protecting the health of the worker. The Supreme Court continued with the liberty of contract doctrine in Adkins v. Children's Hospital, 1923, by holding that a minimum wage law for nurses violated the Due Process Clause. That's interesting. I wouldn't have thought that. The court also used substantive due process to protect other fundamental rights, such as Pierce v. Society of Sisters, 1925. Sorry, man, I'm spitting all over the place. Actually, mostly over my phone. When the court held that the parents have the right to refuse to send their children to public school. That might sound familiar to you now. There's a lot of people deciding to withhold their children or hold their children at home and homeschool them. I have several friends, and we homeschooled our daughter, and she now holds 2 degrees in economics. Not economics, I'm sorry. Politics, something in politics.
International relations. International relations. Is that what you told me?
Right, international relations.
Yeah. Okay,
2 master's degrees. So she's no dummy. Neither was her mom.
She married you though.
Hey, there's no accounting for taste. So after the
brother.
I know you did. After the New Deal and the Constitutional Revolution of 1937, when the court started to defer more frequently to Congress on issues of economic legislation, the Supreme Court's interpretation of the Due Process Clause changed. Regarding Lochner's right to contract, 2 cases went directly against that holding. In Nebbia v. New York, 1934, the state Supreme Court held that the state legislature may regulate prices of items notwithstanding a right to private contract. And in West Coast Coast Hotel Company v. Parrish, 1937, the Supreme Court. I'm gonna have to change my teeth, I think. The Supreme Court upheld Washington's state minimum wage law, effectively ending the Lochner era ideals of the right to private contract, superseding a legislature's economic regulatory abilities. So that sounds like to me, I mean, you can tell me if I'm wrong, or if you disagree with me, I'm okay with that too. It sounds to me like Lochner allowed for contracts that would have a lower wage than what was considered the minimum wage at the time. And in this case, West Coast Hotel Company v. Parrish, they said, no, that's not cool. We have a minimum wage, and you either hit that or you hit the mark above it, but you can't go below, no matter what the contract is. That's what it sounds like to me. If you have a difference of opinion or I'm just flat wrong, don't hesitate to tell me, because I want to learn too. Now there's privacy rights. I'm sorry, did you find something yet?
Found him. And I'm gonna tell you his name. You're gonna be wondering why I couldn't remember it. Okay. Senator Roscoe Conkling, also known as Lord Roscoe.
Okay.
And it was
Oh,
under
that's the
legal
guy.
name.
That's the guy with the corporations are citizens.
Yeah.
Well, I'm glad you
But
found it.
other than that, he's a pretty good guy from what I read.
If we continue down, we're still in clause 1. To privacy rights, the Supreme Court has also used substantive due process to endorse other rights, such as privacy rights. In Griswold v. Connecticut, 1965, the Supreme Court endorsed a right to privacy partially relying on substantive due process. The court relied upon the right to privacy in several other cases involving individual liberties, such as permitting abortions, Roe v. Wade, 1973, and permitting private homosexual acts in Lawrence v. Texas, 2003. Wow, I didn't realize it would be that late. I just assumed, and maybe it's because I grew up in California, and so these things weren't uh, part of our collective knowledge. Everybody does their thing, and everybody else is cool with that. As long as you ain't hurting nobody, go to town. But Roe v. Wade, 1973, and Lawrence v. Texas, 2003, those are very late cases. The Supreme Court did establish a limit to the doctrine in Washington v. Glucksberg when it ruled that assisted suicide was not a liberty upheld under substantive due process. I didn't realize it was 1997. I thought it was much earlier than that. But again, these are important cases because they've established in several different things morals rather than a cut and dry law. These establish morals. In Roe v. Wade, the moral is my body, my choice, basically. In Lawrence v. Texas, the Supreme Court has made it. There's a limit. This is true, but there's a limit to it. That's a moral decision. In Washington v. Glucksberg, the moral decision is assisted suicide is not something we can condone. So, yeah, if you want to commit suicide, we're not even cool with that. But this dude can't help you do it. We'll put him in prison, and you're probably going to die before we figured it out anyway. But and these things, 73, 1997, 2003, these are late 20th century cases that establish moral ground for these rights. And then there's the Equal Protection Clause. The Equal Protection Clause of the 14th Amendment is one of the most litigated sections of the Constitution in its entirety. As a brief overview, the clause refers to the fact that all citizens of the United States are guaranteed equal protections under the law of the United States. When a statute or ordinance discriminates against an individual or a class of individuals, and those individuals sue, the court will apply one of 3 levels of scrutiny to the law in question. This is where I get really, really confused. I think if there's a question of law and it disagrees, it says this in the Constitution, a law may not disagree with the Constitution. The Constitution is the law of the land, the overall law of the land. But they can interpret it 3 different ways, and this is how they do it. Rational basis, which is the lowest level of scrutiny imposed, meaning you can pretty much rationalize it however you need to get your point made, at least as a judge. Intermediate scrutiny, which is what the Ninth Circuit uses, especially on Second Amendment cases and Fourth Amendment cases. This is an intermediate level of scrutiny imposed, typically used for laws which discriminate on the basis of gender, disability, or illegitimacy. Strict scrutiny, which is what the Supreme Court generally uses when they are discussing the 10 amendments to the Constitution. They are supposed to use strict scrutiny. This is the highest level of scrutiny imposed, typically used for laws which discriminate on the basis of race, national origin, alienage, or religion, as well as for laws which infringe on fundamental rights. This is the one This is one of the reasons that the 14th Amendment covers the first 5. If there's an argument in the first 5, they will inevitably every time pull the 14th in to clarify. And that's why it was built in the first place, was to clarify not only citizenship, but to clarify any inconsistencies in the first 5. Apportionment, which is Section 2 of the 14th Amendment. We'll go into that in a second. Do you have anything else, Donovan?
No, I was just trying to figure out this because when I started reading about him 3 weeks ago, and then I couldn't find the tab anymore. With this Conklin guy, interesting. You'll probably find this. You'll find this interesting about him. Sure. So he turned down 2 presidential appointments to the United States Supreme Court. First to the position of Chief Justice in 1873, wow. And then as Associate Justice in 1882.
Oh, he's an old dude.
In 1882, he accepted the offer and was confirmed by the Senate, but changed his mind and refused to serve. He was the last person to have done so as of this year.
Wow. I don't think anybody will actually turn it down. Not now.
So yeah, interesting guy. And he was a big proponent of the 14th Amendment. He's out of New York. And seems to be a bit of a rabble rouser from what I'm reading here, but he was opposed. A lot of those in the late 1800s. He was opposed to social justice reform. Let me sure I get the wording right here. So civil service reform. So he was all for like appointments and stuff like that for senators and their appointments. For doling out it says here, doling out appointed posts, a lucrative and often corrupt practice.
Yeah, still today.
How do you get one of those?
Yeah, you need to get one of those. Yeah. Let me ask you a question, because I mean, it's not directly it's not directly noted here in this section, but what do you think of term limits?
We've talked about this before. So I have 2 views on term limits.
Oh my God, only 2?
Yeah, I only have 2 views on this. I have a view as a citizen and I have a view as a professional. So I think
professional what?
Political campaign operative.
Oh, okay.
So how long you know me? So I think term limits are bad for the people. I think technically there's a term limit every 2 or 4 years, depending on the position, right? So you are up for re-election. And it depends. Yeah.
Unless you count,
you're talking about federal. Yeah, 246. So depending on the position for federal.
Okay.
But I think you start limiting positions like that. You also lose seniority and stuff like that. So then you start to lose people who actually know how the system works, and you may have a different opinion of that sometimes or whatnot. But I think it's not good necessarily for the citizens for term limits. Now, as someone who does this professionally, I'm always about elections. So I think more elections are good for me. So and to hell with the citizens. What do they know?
Well, see, and I was thinking, for me, I think term limits are not how many terms, but how many years. And I would say, for me, I would say 18 years. That's as long as you can serve in Congress, either the House or the Senate together. If you serve 12 years in the House, you could serve one term in the Senate, 6-year Senate term. I'm talking federally. The states can actually make their own term for their states. There's no federal crossover there.
Yeah, I don't think term limits are good for the population at large. If anything, when you start changing elected positions like that, so I guess it's 2 sides of the same sword, right? You get people who are in there and they get a lot of power, and the prevailing thought is, they get corrupted, and the I need another cup of coffee. All these people in the, oh my God, what is wrong with me?
You're a vampire. You sleep all day, but you didn't get enough
I
sleep.
know I should be. The thing is, I should be asleep right now. Help me out here. They are.
Well, if that's all you're giving me, I can't help you. Are you talking about individuals?
No. Industry organizers, all the.
Oh, you're talking about. Oh shoot! I'm sorry, man.
We're going to edit this too, but basically, you have
Guys who go in and lobby them, the
yeah,
lobbyists.
lobbyists.
I had
Yeah,
L, but I
lobbyists.
had Liberter.
I need another cup of coffee. But lobbyists, and I argue, and we talked about this too. Lobbyists are always going to have the power. Lobbyists aren't elected. They are not looked at as, they're not looked at. There's no restrictions on them. Essentially, right. I mean, there are some restrictions on them, obviously, but for the most part,
well, and actually, most of the
unrestricted industry for the most part, I would argue. And yes, right. There are,
but most of the restrictions that you might reference are actually on politicians, not lobbyists.
Yeah, that's very true.
The politician is not allowed to accept box seats to a ball game or right, exactly, and that's the other thing. And that's why I mentioned term limits, is because quote unquote, they're not allowed to accept gifts of any kind. And yet we know for a fact that both sides of the aisle accept gifts all the time because they think it's okay. Nobody nobody that's in Congress today that has been in Congress for more than 20 years is only making their salary. Nobody.
Yeah.
Either side of the aisle. I don't care who you ask or who tells you different. Anybody that's been serving for 20 years or more is not making just their salary.
Yeah. And you can look that up. But so you look at lobbyists, and so the thing is, getting back to the point of term limits and stuff like that, you have new people being elected into office who don't know kind of how things work. Who knows how things work?
The staffers. Staffers and lobbyists.
Come with me and I'll show you how it works.
I think there's a lot of that still. I know that Boebert and Green and there's some new guy also who've never been politicians and spent their first months reading and trying to figure out what it is that they're supposed to be doing, and then finding things that they're supposed to be doing that nobody else is doing.
Yeah.
It's like, wait a minute. No, we're supposed to be doing this. Green has been, once she lost her seat on her committee
seat.
Once she lost her committee seat, she really bore down and learned what is supposed to happen in Congress. And now her big thing is she goes into Congress when they're supposed to be in session, and she sits there, and when they decide to vote on something, she asks for a voice vote so that each individual member has to cast a voice vote, which means they can't just go, because what they usually do is go, okay, Democrats, yay, Republicans, nay, and they go, okay, Democrats win. Well, nobody really knows the actual count. And she said, no, you got to put your name on this. If you're going to do that, you got to put your fucking name on this.
So you don't have to do it that way is what I'm saying, but yeah.
Right. So. Me personally, I had no idea that was happening. And it absolutely blows my mind that how possibly lazy could you be at doing your job when you show up 3 months out of the fucking year? You show up for the big things. Oh yeah, what are we voting? Oh, okay, yeah, you have my proxy to vote that way.
Well, it all depends on how they do it too. Even the state legislatures are all different too. So,
but anyway.
My point is, back to term limits, is the power is always going to be with the lobbyists, right? So whether you got new people coming in who don't know what they're doing, or you got people who have been entrenched there for 20 years or more, who know all the lobbyists too. So you're always going to have kind of that. I think having, I don't, term limits, I don't think help the populace at large. I think they like to think the idea of it is, I see the idea of it is that, yeah, you change people in and out. But what it's also done, particularly in California, you can talk about this too, is it's basically done like, musical chairs of all these elected officials going up and down the ladder. I was a congressman, now I'm the school board, the president, and this, that, and the other. So, I mean, you still have the same people running for different offices. So, it also makes it a little bit more cannibalistic within the elections and within the parties, in California, more so with the Democrats and the Republicans. But also, you look at some of the other red states too and stuff like that, you get some of that as well. So you're always going to have those people.
Well, I think as long as we have a two-party system, it's going to be
It's
cannibalistic.
going to be that way.
I'll tell you what. Let's get back to the 14th just real quickly.
Yeah. So
because
you asked me what I thought about term limits. So, but I still think term limits not good for the people. Good for people who work in campaigns and elections, like myself.
Sure.
So that's those are my 2 points of view.
And that's fair. I want to talk specifically about disqualification for rebellion. Section 3 of the wait. That's in section 3.
That's section 3. We were just doing the first 2 sections, right?
We're just doing the first 2. So yeah, apportionment.
Yeah.
That's just apportionment, and that's, for me, that's like super basic. I mean, it's like trying to read numbers in the Bible. It's numbers, giant numbers that honestly don't mean anything to me. I would never be able to memorize that book of the Bible. But in section 2 of the 14th Amendment deals with apportionment of representatives from the southern states. The abolition of slavery meant that the representation of the former slave in the House of Representatives increased. This clause of the 14th Amendment was drafted to encourage southern states to grant blacks the right to vote without forcing them to do so. Congress did not really try to enforce the clause. In Saunders v. Wilkins, 4th Circuit, 1945, a candidate for Congress from Virginia sued under Section 2 of the 14th Amendment, trying to force the state to adopt an at-large electoral system because the state was not eligible for the 9 electoral seats it had been granted after the 1940 census. The court dismissed the case as a political question. This section is still in operation and would operate in further future cases of rebellion. The Supreme Court affirmed in Richardson v. Ramirez that under Section 2, states can prohibit convicted felons from voting after serving their prison sentence, and taking away the right to vote is referred to as a disenfranchisement. And you can read more about that in a Wex article titled Civil Rights. And that's all they really talk about, at least in this section, or in this particular Cornell Law School article about the second clause. Because honestly, it's like reading the book of Numbers. For me, I mean, it's specific enough. They needed this clause to be very, very specific in that we count every male over the age of 21 as a citizen. And that was important to get the right amount of representation in the House and the Senate. The Senate always has 2 per state. The House has, is it 1 per 100,000 citizens? I think
it's 500,000.
How many?
500.
500,000?
It could be different in different states. I don't know how that works out.
I don't think so, because it's
all the same. It's all the same. It's all federal.
I think so. Yeah.
I think California was like 500. I mean, our population is so large there. That's why you have a lot of them sometimes, depending on.
Well, yeah, but we lost like 100, just a little over 100,000 people, and lost a seat because of that.
Yeah, we lost a seat. Yeah.
So that's why I'm thinking 100,000.
Texas gained. Colorado gained. I don't remember who all was, but yeah, but I live in Colorado, so I remember that. So Colorado gained, I think Texas gained, and California lost.
Yeah, because everybody was leaving California, and they went to Texas and Colorado. Go figure. Go figure. A lot of businesses moved from California to Texas and took people with them. So they offered a lot of their executives moving expenses and stuff like that. You wouldn't get that if you were a warehouse worker on the floor, but you might get better wages and certainly got a cheaper house. Although I understand real estate taxes are freaking stupid high. But if your house is $174,000 and it's 3 stories and you got 20 acres, I think it probably breaks down even. Anyway, so that's what we have for, that's what I have for the 14th Amendment first 2 clauses. Do you have anything new?
Yeah, I'm actually looking at the 2020 census for apportionment.
Oh,
So
okay,
yeah,
great.
it looks like it varies by state because of population numbers.
Okay.
Yeah, so like Alabama, average persons per representative, 686,000. Alaska, 721,000. California, make sure because this is all itty bitty writing, 704,000. So,
Oh, okay.
yeah, so
So we must
they,
have been on
they,
the
they
bubble
probably
for
got to
what?
wait. They probably got a way to figure all that out, like a percentage. It's not like an exact number per se.
Right.
Uh,
Well, it
but
sounds like that seat that we lost must have been on the bubble for only 100,000 to make that difference.
yeah, seat change. It says here. I'll keep this. This is actually pretty good. I'll put that in there. The U.S.
Okay,
Department
yeah.
of
Yeah,
Commerce,
well,
U.S.
absolutely.
Department of Apportionment population and number of seats in U.S. House of Representatives by state, 1910 to 2020. But this is through 2020. So, yeah, interesting. I've never seen that. So, but it seems like I remember when I was, because I remember I did a supervisorial race in the 90s in Santa Clara County. And the supervisorial seats, at least in the 90s, in Santa Clara County, were 350,000 people. And it was like almost the size of a congressional seat. And I think congressional seats were 500, it seemed like, in California at the time. So,
Okay.
so this says 700 now. So that was 20 odd years ago. So,
Right.
but yeah, but I remember it was being quite large. But like, you look at some states, have, like I was in North Dakota, there's 700 something thousand people in that state. So
Yeah. That's Los Angeles.
yeah, so yeah, so it's like, but the city of San Jose is 1 million people, right? So yeah, so you look, so yeah, it's interesting to see how they do that. But yeah, so yeah, I'm good. I'm good. Conkling, it was bugging me. I couldn't remember his name for life of me, man. Who was that guy I was reading about?
All right. So
Roscoe Conklin.
after the edit, we hope you like this. And honestly, if you could help us out, hit that like button, push us up in the algorithm, share this out if you think somebody needs to hear this, or you just want to annoy other people. I would appreciate that. Do anything you can to help us out. Leave a comment. That actually makes a lot more difference than a like or almost as much as a share. But yeah, do those things for us. We would really appreciate that. And I don't really have anything else. I think Donovan said he was clearly done.
I'm tired. I'm
So-
sorry, man.
No worries, man. We got it covered. That was the thing. So thank you very much for watching. We really do appreciate you. And you have a great night. All right, Donovan?
Peace out, people. Be safe out there.
See ya.
Well, I'm Donovan, and John's here with us today. Thank you for joining us for the free exchange of ideas, and we'll see you next time on the next show. See ya!